Hello and welcome to this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. I'm Surisha Gunta, Counsel and Education Director with PBPA. Before our speakers talk about today's topic, how to navigate technology and Clickwrap agreements, I'd like to tell you, our viewers, a little bit about PBPA and our mission. PBPA provides free business legal services to Atlanta area nonprofits. We connect them with volunteer attorneys from Atlanta's leading law firms and corporations. PBPA provides direct legal services to our clients, and we also provide free resources to any interested nonprofit on our website through our Learning Center. So who are PBPA clients? They are 501c3 nonprofits that are located in or serve the greater Atlanta area, and they themselves serve low-income or disadvantaged individuals. Our clients are otherwise unable to afford legal services. So if you're interested in applying to be a client or to get more background information on client requirements, please visit our website. Also, on our website at our Learning Center, you'll find a ton of great resources related specifically to small Georgia nonprofits. There you'll find articles and podcasts and webcasts, including this webcast, which will be posted on our website in a few days. Now, keep in mind that today's presentation and any questions that our speakers may answer today is not legal advice. It's just general information. Reach out to an attorney to talk about your organization's specific needs. This presentation will be recorded, and a recording of this presentation and slides will be available on our website in a few days. And today's presentation is copywritten. And now, I'd like to introduce our speakers, Josh Gans and Maha Kalaj. We have two attorneys from Kilpatrick Townsend speaking to us today. Maha is a senior associate at Kilpatrick, where she focuses her practice on technology transactions. She has also been named both last year and this year to the list of best lawyers ones to watch in America. Josh Gans is co-leader of the technology, privacy, and cybersecurity team at Kilpatrick Townsend. In addition to advising global businesses on complex technology transactions, he's also a longtime PBPA volunteer. He has advised numerous nonprofits on exactly what we will be talking about today. I also want to mention that both Josh and Maha have served on the board of directors for some of our clients, so they know well the concerns of small Georgia nonprofits. I'm thrilled that they are both here today to speak to us today. Josh and Maha, thank you so much for joining us. And I'll give you the floor so that we can talk about technology agreements.
Thank you, Surisha. I'm Josh Gans, and thank you very much for that introduction. We are very excited to be here and talk to you about Clickwrap agreements and some of the issues that surround those. Before we get started, just to reiterate a point that Surisha made earlier, only a few slides ago, the presentation here really is intended to be general information for informational purposes. Each situation is different, each client is different, and each potential technology transaction is different. So again, wanted to be clear that you should always consult with an attorney with respect to any particular matter. And we also like this graphic, so we thought we would say it twice. Go to the next slide, please. So to kick off today's discussion, and I know the attendees and the future viewers of this webcast don't really have a great opportunity to respond, at least through audio, but I'll ask a few questions. What is a Clickwrap agreement? I'll go ahead and answer that. So a Clickwrap agreement is typically online terms and conditions that apply to your use or procurement of a particular technology tool, whether that's software that you're downloading, whether that's a website that you're browsing or communicating with in some fashion, or the newest and latest and greatest software as a service tools. Clickwrap agreements can also apply to things like professional services, although that's a little less common. But in any event, Clickwrap agreements are typically housed online, accessible via a web link. And because of that, they often appear to be non-negotiable. And we'll get into that in a little bit. I'll get to my next question. Do you review your IT contracts or Clickwrap agreements, or do you just sign them? I'll answer that for you as well. I think we set up the last question and asked what a Clickwrap agreement is because of the fact that many organizations believe that if it's a Clickwrap agreement, meaning it's housed online, that it's not subject to negotiation or review, that it's sort of a take it or leave it from the particular IT vendor. And that's not always the case. And that's what we're going to get into during today's presentation and discussion. But in any event, your answer to question number 2, we hope after this presentation at least, is yes, you do review them. You might just sign them depending on the circumstances, but at least you'll be armed with a little bit more insight into some of the issues and perhaps ways that you can address concerns that you might have with any IT project going forward. And then the third question, if you do review your IT contracts, how many have you negotiated? Again, unfair question to ask on a webinar because you don't have a great mode of responding, but hopefully after this will help you, like I said, give you some tools to review and address those going forward. Next slide, please. So to preface, everything is negotiable, whether it's an online set of terms and conditions, or it's an actual hard or electronic copy of a contract that's provided to you by an IT services provider. At the end of the day, everything is negotiable, sort of, but and that all depends on you and your preferences and your willingness to enter into a contract with an IT vendor where you're not entirely comfortable with the terms. And that, and again, we'll get into that in a little bit more, but ultimately the best leverage in any contract negotiation is the ability to walk away. So with that, everything is negotiable. Next slide, please. Okay, so just to walk you through the agenda for today, we are going to hit on 5 sort of high-level topics here. The first topic being, why do IT transactions fail? The second topic is common negotiable contract terms. And Maha is going to set up the beginning of the contract common negotiable contract terms. We're going to touch on what we believe to be the most material and probably the ones where you would have the greatest ability to negotiate should you have an issue or really have any concerns about those contract terms. We're obviously not going to go through every contract term or term in a contract, but again, we think this will set you up for a good review and potential success in the future. The third topic is tips on retaining control of your data. 4 is ways to mitigate risk internally. And then the 5th high-level topic will be options for termination. Next slide, please. Okay, so I'm going to kick off with why do why do some IT transactions fail? Next slide, please. So there are a lot of reasons, and this is certainly not an exclusive list of why, but we will start off with a few. So number one, a poorly defined scope can often lead to a failure in IT transactions. At the end of the day, the provider is responsible for providing what is listed in the contract. And that'll sort of be a theme as we go through a lot of these issues today. But I think the rule of thumb should be, if you believe it to be a material part of whether it's services or a piece of software or a SaaS tool, if there is something that is key to you and your organization in terms of what needs to be done or provided to you from that IT services provider, it needs to be stated in the contract. If it's not, it's not part of the contract. And I know that sounds simplistic, but in addition to assisting clients with entering into contracts, we also, unfortunately, have to help clients sometimes get out and figure out ways to get out of the contract. And again, a common theme in terms of issues that we see going forward is that, what our clients thought was the material part of the contract or the benefit of the bargain was never actually really stated in the contract, whether it's through the statement of work or the order form. It just never ultimately made it into the contract. And that unfortunately, that can happen sometimes during the sales process. So anyhow, poorly defined scope is one of the main issues why IT contracts go awry. Related to that is the description of your responsibilities as the customer. Oftentimes, whether it's a professional services engagement, you're having an IT vendor come in and perhaps do some coding or work on your network or set up your IT infrastructure or implement a SaaS tool. Oftentimes, it's not all going to be on the vendor in terms of them performing all the activities and bringing all the materials to get the project complete. There are, in most cases, if not all cases, going to be responsibilities of you and your organization in order to assist the IT vendor in doing what they need to do. And at a basic level, it could just be access to systems, but more often it really is more of a specific level of resources that need to be provided, data that needs to be provided, information that needs to be provided. So it's really important to make sure that as an organization, you are reviewing those customer responsibilities and making sure that these are things that you can actually do, that you have the time to do. Everybody has a day job, and it's hard when you're going through a big IT project to find additional time to assist the vendor. But that is another key to success, is making sure that you've read those customer responsibilities, you're comfortable with them, and to the extent that they're high level and not descriptive enough for you, ask for more specificity from the vendor in the contract so that there are no there's nothing hidden, right? And that you can actually perform what you need to do to put the vendor in the best position to make the project successful. Number two, poorly defined business objectives. These are also really important, right? It's not just important to specify the steps that need to get done as part of the project. You want to define what's the overall business objective, right? What are we trying to get to? We're trying to implement a system where we can take credit card payments from our donors for particular events, and we can push back out receipts to them. That's just an example. But in any event, you want to make sure that your business objectives are aligned with the solution that the vendor is going to provide to you. And that's not just part of the contract. That's not just necessarily part of the contract. It's part of selecting the right vendor. Planning is key, right? For any IT transaction, for really any business transaction, planning is key. But particularly with selecting a vendor, if possible, and Maha, I think we'll get into this in a little bit, leverage an RFP process. And when I say RFP, that's a request for proposal. It doesn't have to be a very detailed, long, drawn out proposal process, but it's really helpful to get these things pinned down on the front end with your IT vendor to make sure that you're on the same page and to make sure that their solution is what you need. Again, oftentimes when we're unfortunately helping our clients get out of these IT transactions, it's because there was an alignment on the front end in terms of the business objectives. And sometimes that can get lost in the sales process. Salespeople are quite good at what they do. They sell. Sometimes as a customer, you might think that a particular SaaS product is going to get you what you need, but it might not. So again, defining those business objectives up front, if you can, leverage an RFP. And in that RFP, it's really good to detail out exactly what your business objectives and both at a high level and at a specific level, and get that to the vendor in advance. It will really help the level setting, and have your list of must-haves in that. And I think today, hopefully after our presentation today, you'll have a greater ability to come up with a list of must-haves that you want in any IT contract. So must-haves can be commercial terms, and they can be legal, and they can be technical as well. But putting that in front of the vendor in advance can be really helpful, again, for level setting, making sure everybody's on the same page. Okay, number 3, unclear pricing methodology. And we're going to touch on a few of the more common pricing methodologies a little bit later today. But a lot of times it's not clear. It's really just not clear to the customer how the services are going to be priced. And that can result in unplanned price increases to the customer, or blown estimates, exceeded estimates. So we'll talk about that a little bit later, but that's another reason why we see IT contracts fail. Number 4, lack of service provider accountability. This is really all related to some of the ones that we previously talked about, like a poorly defined scope. But in addition to poorly defined scope, it's what are the remedies that you as a customer have? Remedies being, what is your recourse if the service provider doesn't do what they're committed to doing? And there are a variety of ways where Clickwrap agreements sort of disclaim a lot of accountability, and we'll talk about that later. So through disclaimers and sole and exclusive penalties and remedies, but that's another reason why we see IT contracts fail, is because at the end of the day, the provider really wasn't on the hook to do anything, and it wasn't their risk to bear. Number 5, inadequate measure for performance. And I know Maha is going to talk about this a little bit later. So service level. So it's not just what are they going to do for you? What is the provider doing for you as a customer? But 5, what we're talking about here in terms of the measure for performance, what's the quality that you're supposed to receive? It's great that you can log into a reporting tool that you may have licensed from a vendor, but really from a quality standpoint, what are your expectations? Is there a certain level of availability that you would hope to receive in terms of being able to access that tool? If it's processing transactions, how quickly are those transactions being processed? So that this is more of the quantitative aspect of what are you getting from the vendor, and that's typically through SLAs or service level agreements. 6, ineffective change management. This really gets into making sure that your organization is ready to change from one tool to another. Often, most times, right? Anytime there's a change from any type of IT tool, whether, for example, I can give a specific example at the firm. We just changed our financial reporting tools. A lot of them are very similar, but they're also very different. And so the little things in terms of teaching your organization and training your organization on how the new solution is going to look is very, very important in any IT transaction. And that's not really something that you put on the vendor. You might get training from the vendor. So that's very important. So consider whether that's something that you would want as part of what you're buying from any vendor. But that is really a very important thing for organizations to think through, that training and change in any IT tool takes time. And planning for that is critical. 7 really sort of relates to 6, but a little different: lack of executive organizational support. Just making sure that there's organizational buy-in to any IT project. Making sure that if your organization is going to spend a lot of money on a new tool or a new process, that people are actually going to use that tool within your organization. Again, that relates back to number 6 somewhat. And then 8 is poor post-transaction deal management. I hear this term a lot. Well, we're just going to sign this contract and put it in a drawer and never look at it again. Hopefully that's the case, because that means that everything's gone well. But sometimes it's not. And so if you're going to spend the time to review, plan an RFP process, review and negotiate both commercial and legal terms with an IT vendor, actually use the contract when you need to, right? There's a warranty issue we'll talk about in a little bit. Make sure that you're looking at what the warranty and the contract says and managing to those timeframes. If you have SLAs and you've negotiated SLA credits, try to get those SLA credits if there is an SLA failure. Anyhow, so poor post-transaction deal management is, really, even after you've signed the contract, you've implemented the tool, you do want to make sure that you're also managing the vendor and using what's in the contract and outside of the contract from a relationship standpoint to make sure you know what's going on and keep the vendor accountable for project success. Okay, sorry, spent a lot of time on that slide. Now I'm going to turn it over to Maha to kick off common negotiable contract terms.
Thanks, Josh. Hello, everyone. So the good news is, as Josh alluded to, you can mitigate some of the risks associated with the pitfalls that Josh just described by making sure you review and understand certain key terms in your IT contracts, because after all, you can always walk away. But then also try to negotiate the most favorable position that's possible for your organization. So next, we're going to cover some of the more commonly negotiated terms in IT contracts that you'll want to be sure to review before signing. Next slide, please. So here is the list of terms that we're going to cover today. Of course, this is not an exhaustive list, but certainly covers terms that at a minimum, a customer should always review. We'll kick it off with a discussion about scope of services, then move on to pricing, performance warranties, service level agreements, and then wrap it up with termination clauses. All right, so let's start with scope of services. This is where, as a customer, you will always want to ask yourself 3 questions: who, what, and when. On the question of what, A customer should always review the scope or description of services, which typically will be covered more generically in the main agreement and then in greater detail in the statement of work if there is a statement of work. If there is no statement of work, then you'll want to make sure that the agreement itself adequately covers the scope of services. And when you're reviewing the description, it's helpful to think about what result you expect to achieve from using the vendor services, and then all of the tasks that need to be completed in the process to ensure that you do achieve that result. So it's important to identify any key tasks that the vendor needs to perform, such as implementation or configuration of a cloud service, for example. Are there any training or consulting services that you expect to receive? Does your organization have any business or technical requirements, such as compatibility with your existing software or equipment, that need to be accounted for? And then, what about scalability? Do you need the ability to scale the service so that you can increase or decrease the number of authorized users on the account and certainly receive a corresponding adjustment to the fees? So any and all of these should be clearly covered in the agreement. You should never assume that statements made by the vendor during the sales process or RFP stage will hold true during the contract term. So as Josh stated, it is very important to make sure that during the RFP stage, you discuss everything that you need up front, but then you want to make sure that everything that was, that took place during the RFP stage makes it into the contract. Because if it's not in the contract, it's difficult to hold the vendor accountable for those things if the relationship goes awry. So it's very important to think about what your business and technical requirements are, and then just make sure that they're covered in the agreement. And then on the question of who, the contract should clearly allocate responsibility to the vendor for performing those tasks that are necessary to achieve that result. And if the contract includes any tasks that you're responsible for, then you'll want to make sure that those are described in detail and with specificity so that you can avoid a situation where the vendor is trying to hang its hat on something to justify their own delays or performance failures. So make sure any resources or information that you're required to provide are described in detail, and also include timeframes for when you're required to provide them to the vendor. So for example, if the contract vaguely states that you'll provide personnel, you should try to be more specific about the number of personnel you need to provide, so that the vendor can't try to justify its failures, for example, by claiming that you didn't provide enough. And then on the question of when, so to hold the vendor accountable for timely performance, of course, you'll want to make sure that the contract clearly includes deadlines for any milestone activities, deliverables, or go live dates, because after all, without deadlines, you could be held responsible for potentially paying for a service that you haven't received yet, depending on the payment terms and whether any other remedies are available to you under the contract. Next slide, please. All right, so here are some common issues that we tend to see relating to scope of services. So first, the scope is too general and doesn't offer enough to understand what the vendor is really responsible for providing, which makes the contract difficult to enforce. So if there is a specification that describes the specific offering that the vendor is providing and the related services, then often it's helpful to include that document as an exhibit to the agreement, or incorporate it by reference. Also, if there is a statement of work, we often see conflicts between what's stated in the master agreement versus what's stated in the statement of work. A lot of times the master agreement is negotiated up front, and then statements of work may come at a later time. And then vendors will usually want the statement of work to prevail in the event of any conflicting terms, so that they can later incorporate more favorable terms for themselves. While customers will want the master agreement to prevail, given the time and resources that were spent up front negotiating the master terms. And a lot of times the master terms will be negotiated by attorneys. So, the customer will want those terms to prevail. If you don't win on getting the master agreement to govern, then it's important, of course, to carefully review the SOWs and clear up any conflicts prior to signing. And then moving down the list to the third one, oftentimes vendors will also litter the scope of services with assumptions, dependencies, and customer responsibilities, which, basically they'll include to protect themselves against their performance delays or failures. So these should be reviewed very carefully and to the greatest extent possible, limited. And when you're evaluating each assumption and dependency, you want to consider whether the vendor should be excused for untimely or failed performance if that assumption or dependency fails to hold true. So if the answer is no, that they shouldn't be excused, then that assumption or dependency should either be deleted altogether or revised in such a way that would justify a performance failure. And then lastly, you'll want to pay close attention to what the vendor has described as being out of scope and make sure it's accurately described and can't arguably include any services that you expect to be in the scope of services. Oftentimes it is beneficial to include what we call a sweeps clause, which is basically a clause that states that the vendor will perform any services, activities, responsibilities that are required to provide the product or service that you've purchased, which helps fill in the gaps in your description of services. Vendors do push back on that generally, but doesn't hurt to try. Next slide. All right, I will pass it back over to Josh for discussion on pricing.
And thanks, Maha. I think one thing that's important to also highlight here is really the interrelation of the terms that we're discussing here today. The scope of the services obviously can have an effect on the pricing. But I think one thing that Maha just mentioned was the assumptions and the fact that assumptions are really included as a mechanism to put guardrails around what the vendor is providing from the vendor's perspective. And in other words, if those assumptions are not met or are exceeded, it's typically going to come along with a price change or a scope change or a timeline change. Maybe to simplify, that's one point. On the converse, there's really an IT sourcing equation. Let's say you've got the scope of the services plus the quality of the services times the timeline, equals the price. And so if there's a change on one side of the equation, there's going to be a change on the other side. So in other words, lower price, might come with lower, level of service. Or if you as a customer want a higher level of service, that might come along with a higher price. Or if you want something to be done faster, that might also come along with a higher price because the vendor will have to typically hire additional resources to get things done more quickly. So anyhow, I wanted to highlight that. I think that's an important thing to note. But also, I think the fact that assumptions and the way that they are used by vendors to, again, to sort of cap their exposure and allow for some relief as it relates to pricing, any pricing commitments that they've made to you is a really important point to make. So I'm going to talk to you about common pricing methodologies. You know, there are a variety of different methodologies or ways that an IT service can be priced, and it really all depends on what you're getting. You know, if we're talking about services, you know, fixed fee, cost plus, time and materials, milestone payments. These are various ways that that pricing can be addressed. If you're talking about software licenses or SaaS licenses, you know, that's typically really just that's typically a variable pricing methodology, and you can have some fixed fees, but it's usually variable in the sense that, you know, if you have 15 users, you're going to pay for 15 licenses. And in the software and SaaS space, even though it's variable, it might be variable going up. It's typically not variable coming down, right? So in other words, if during the term, if you've bought 15 licenses and during the term you need to go up to 20 licenses, vendor will be happy to give you 5 additional licenses at some you know, incremental license fee amount. But if you've signed a, giving an example here, if you signed a 3-year term to license a piece of software and you need to go down in your usage, that's typically not something that vendors are willing to give. You know, I'd like to say that if that's important to you as an organization, if you know, for example, whatever you're licensing from a vendor, your usage is going to drop over the term, you would have to negotiate that up front, and probably push pretty hard to do that, because oftentimes vendors want you committed for the entire term. But going back to services, there really are several different ways that that services can be priced, and they each sort of come with pros and cons. So a fixed fee, that's, you know, that's a commitment up front from the vendor that they're going to do everything that they've promised to do for you for a fixed amount of money. And these can be really helpful to a customer, right? Because you know what your cost is going to be. You have visibility into what your budget for the project is going to be. The challenge with it is, you know, with a fixed fee, because the vendor is taking the risk that everything that they need to do, they're going to be compensated for by that fixed amount. They're going to build in a lot, probably a fair amount of assumptions and dependencies on what you as the customer need to do. And they're probably going to rely on you through a variety of customer responsibilities. You know, so where we see services transactions go wrong with fixed fees, it's because, you know, the customer sort of thought that everything was included for this price, but the reality is a lot of it was disclaimed or assumed away through the assumptions and dependencies, and ultimately the vendor came back and asked for more money because those assumptions were not met. So, you know, fixed fees can be really helpful if you're really clear on the front end about what you are getting from the vendor and what you as the customer need to do in order to make that project successful, and you can commit to that. Otherwise, you know, you might expect change orders and additional fees to be passed through by the vendor, and you might not meet your budget. I'm going to skip over variable because I discussed that one earlier. I think that's more of a software pricing methodology. Cost plus, you know, this is probably the most beneficial to the vendor. Cost plus would be, you know, whatever our cost is, we pass through to you, and then we take some sort of the plus part is a management fee or a administrative fee. You know, I'm giving an example. Let's say it's a 10% plus, right? You know, this is great for the vendor because really anything that they do, any cost that they absorb in performing the services, they'll pass through to you. This is typically used in a project where, you know, the vendor has to go out and get third parties to do a lot of work for you as the customer. You know, they might not have the ability to control that cost with the third party. but they also need to make their margins, so they take a plus component of that. Again, this is probably the most beneficial to the customer. I'm sorry, to the vendor. You would probably see a lot less assumptions and dependencies in the contract in terms of what the customer needs to do. But if you do a cost plus pricing methodology, I think you'll want to build in some administrative or governance practices to make sure that, before the vendor goes out and it incurs a third-party cost, that they're coming to you and they're getting your approval, and that you really understand what costs they are incurring, so that you're not just getting stuck with a bill without really any due process or administrative or governance. The next is time and materials. This is another very similar to cost plus, but this is where the vendor is using mostly its own resources to provide the services. T&M, time and materials. Here you typically get a rate. You get a rate card, and whatever hours the vendor's resources spend, they would pass through to you. They would charge you, hours times that rate. Surprisingly, we've actually seen some contracts where, that the vendor has stated, we will charge you on a time and materials basis. They might even give an estimate, but there aren't any rates. The vendor actually didn't include any rates in the contract. So there's really no way for the customer to substantiate, hey, are these fees right? Because they don't have the rates to multiply times the hours that were spent by that particular vendor resource. So, time and materials, you really want to make sure that you do have the hourly rates in the contract. And that probably goes without saying, but I thought I would highlight that I've seen it before. You might ask for a cap with a T&M pricing methodology, and that's fine. I think a lot of times customers often think that the T&M with a cap is like a fixed fee. It's really not. The way that I see it, it's more of a governance mechanism. Basically says, vendor, if you're coming up to this cap, you'll notify me, and then you won't proceed with further services until I give you approval to exceed the cap. But again, so I see this as more of a governance mechanism. You as the customer have some visibility into when your budget or your sub budget might be hit. And then you have another discussion with the vendor on how do you increase that cap. The last common pricing methodology, which I really think is a helpful methodology, is a milestone-based payment. And this can be used whether there's a fixed fee or it's a time and materials pricing mechanism. But the milestone payment is basically, hey, you don't get paid for this particular aspect of the project until you've completed something. So in other words, you're not just paying for the vendor to do things and to spend time on things, you're actually paying for outcomes, right? So if your project is a 5-stage project, you divide that up into milestones. And at the end of each milestone, you'll review whether that milestone has been hit and completed. And if it has, then you release a payment to the vendor. Again, whether that's based on a fixed fee that's cut up into installments, or it's T&M based, where you would pay the vendor for all of the time the time that they spent up to that milestone. But having a milestone payment is really helpful, because again, it sort of shifts the calculus to you as a customer paying for outcomes rather than just paying for time without any outcomes. Another thing to note, beware of the estimated fee. It's just an estimate. It doesn't really provide any price protection if it's called an estimate, unless, of course, like I said, you build in some governance and administrative process around the vendor notifying you of where they are against the budget. You're periodically meeting with them to do so. All right, next slide, please. I'm going to run through this one quickly. I know we're coming short on time. Couple best practices. If you're moving from one tool to a newer tool, just understand what you were paying before you move to the new tool and what you're going to be paying after. Obviously, everybody has budgets. We want to stay with those. And so understanding the pricing methodology for your new tool can help you make sure that you're not ultimately paying a lot more for the new tool. I think we talked about this. Understand the vendor's pricing model. If it says T&M, time and materials, and they'll bill on an hourly basis, but then they don't actually provide you with the hourly rates, that could be an issue. So understand the pricing model. Scalability in pricing, I think Maha had talked about this a little bit earlier. If you're licensing software, and right now you only need 10 seats or 10 user licenses, but in the future you might need 5 more. Ask for a per user or a per seat license fee so that you can increase that software usage going forward and get that up front. The next bullet point, include a rate card, pricing list for future purchases. These are great so that if you do want to use that same vendor to do a related project, or even something that's part of the project but not currently in scope, get a rate card in advance that shows the hourly rates or a pricing list that you can use. Minimum revenue commitments, volume commitments, particularly in the services space, I would try to avoid if at all possible. Software, it's a little different, as I mentioned earlier. Vendors are going to want you to commit to at least one level, a minimum level of software usage going forward, and typically won't want to agree to your ability to decrease usage of that software or SaaS product. But again, if that's important to you, try to negotiate that up front. And then avoid contractual language that allows the vendor to increase fees without any actual due process. So there, oftentimes you will see language that says, if the scope is exceeded, or if things are different than the vendor understood, that they can increase fees. Press on that. Ask, well, what does this mean, and how can you increase the fees? And if this were to occur, what's the mechanism that we use to negotiate a price increase? Okay, next slide, please. One of the biggest tools that you will have in your contract in terms of remedies, contractual remedies. Number one, what are you getting from the vendor? And number two, what can you do if you don't receive that from the vendor? Is the performance warranty, and this is really more important, or this is more critical, I guess, in the software and SaaS solution space. And this is the language that says, the vendor or the service provider agrees that the software or the SaaS solution will conform in all material respects with the documentation that they've provided you. Oftentimes, particularly if you're not negotiating many of the terms in the contract, this is really your main recourse as a customer. So review it and look at it and make sure that there are some remedies associated with it if the solution or the software doesn't do what it says it will do in the documentation or the specifications. Oftentimes there is a commitment from the vendor to, if the software is not working, to repair it or replace it with new software that's not defective in a certain period of time. So make sure you understand what's in the performance warranty, because again, for software SaaS, this might be your main recourse. But also study the timelines, right? How long do I have to make a warranty claim? Is it 30 days from the date that I signed the contract? Well, okay, that sounds like a long time, but what if I sign the contract and then the software is not implemented for 6 months or a year? Well, your warranty's already run up. So review that, study that, and make sure that it all makes sense to you in terms of how quickly are you going to use the software? How quickly is it going to be implemented? Another example would be if this is a quarter end or a year end financial reporting software or an audit software, does that warranty provide you enough time to actually test it during that seasonality, during that quarter end, where you're gathering all the numbers and the volume of data that's running through the solution might be higher. So study that and look at the time frame and make sure that it's long enough for you to make a warranty claim. I guess another related point is that you'll want to make sure that there's a termination right as well, associated with that performance warranty. If the service provider can't fix the software or the SaaS product, ultimately you want the ability to get out, because again, this is your main source of recourse against the vendor. So try to get a termination right if it's not already in the vendor's form as it relates to a performance warranty failure. Okay, next slide, please.
All right, turning now to service level agreements, or SLAs. As Josh mentioned earlier, service levels are metrics that measure the level of service that a SaaS provider provides. So because SaaS solutions are remotely hosted, service levels are often critical topics in SaaS agreements, especially if the solution is critical to your organization, to the business, or if the vendor hosts sensitive customer data. And the more critical the service, the higher the chances that a service interruption could seriously impair your ability to perform critical functions, and therefore the risk is much higher. So although SaaS providers are a lot of times, reluctant to negotiate their SLAs because they do want fixed service levels across their entire customer base, you should still try, especially if the solution is critical to your business, because we do negotiate them. They are negotiable. And why is it important? Because service levels are, as Josh mentioned, intended to ensure that the customer can rely on the services, and they often include appropriate remedies for service interruptions and failures. And most importantly, they are there to incentivize the vendor to provide consistency and to diligently remedy any service failures. So when you're evaluating the service levels, you might want to conduct some due diligence on that vendor before signing by asking others who've engaged that vendor about the level of service they received, so that you can gain some familiarity with what you can expect. And also, if you are replacing an existing solution that you're using in your organization, then you'll want to compare what you're receiving from that existing vendor against what the new vendor is offering, and try to avoid contracting for less than your current performance level, because after all, you don't want a solution that is worse than the old one. And then based on that assessment, you can determine what minimum and expected levels of services you need from the new vendor. Next slide, please. And here are some things you'll want to consider when you're studying the vendor's service level agreement. So the most common type of service level measurement is availability or uptime. There are other service level measurements such as response and resolution times, but in the interest of time, we're not going to cover those in detail today. So we'll focus on availability. So an availability or uptime service level requires the vendor to ensure that the solution will be fully available for access and use for a specified percentage of time during a defined measurement window, which typically is a month or a quarter, preferably monthly. So you'll first want to look at how availability or uptime is defined. Is it tied to functionality or access? As a customer, you'll want it to be tied to functionality so that inoperability of any software feature is considered an outage, unless of course it falls into some sort of exclusion that you've agreed to, which, we won't go into the exclusions in detail, but ultimately you want them to be limited to the greatest extent possible. And in the best case scenario, the only exclusion would be scheduled downtime. And then you'll often see formulas in the service level agreement. And that formula is there for the calculation of uptime, and it'll typically be tied to other definitions. So you want to closely review the definitions, plug in some numbers, and test out any formulas so that you can avoid any unintended consequences and make sure the formula works. And then look for an obligation on the vendor to issue credits, because if there are service failures, then what is your recourse? In order for the SLAs to have any bite, any failure by the vendor to achieve those service levels should result in some sort of financial consequence, which is most often achieved through service credits. And those are generally applied towards your future use of the SaaS service. Although SLAs, although they are generally credits only and not refunds, sometimes customers will push for a right to a refund in the event that you're at the end of the contract term and there are no further fees against which to take the credit. Also, sometimes you'll see the credits referred to as a penalty, which you'll want to reject because penalties are not enforceable. So make sure that they're appropriately referred to as credits. It's helpful to include language that states that they are not penalties, but rather price reductions in response to a reduced quality of service. It's also important to make sure that the service credit calculation is clear and easy to apply, and that the service credits are significant enough to incentivize the desired performance. And then lastly, reporting. You'll want the SLA to include an ongoing reporting mechanism for measuring the expected availability standards, which should be the vendor's responsibility to provide. Sometimes you'll see language that requires a customer to claim the credits during a particular time frame that falls before the time the vendor is even obligated to deliver the report, which you'll want to avoid for obvious reasons. You can't claim credits for reduced performance when you haven't received the very document that reports their reduction. So watch out for that. Next slide, please. Okay, this chart shows the amount of downtime that's associated with certain availability percentages. So for example, halfway down the chart, look at the difference in downtime between 3 nines and 5 nines. It's a difference of over 8.5 hours per year and 40 minutes per month. And so that amount of downtime could be crucial depending on how important that SaaS service is to your organization. So it goes without saying, as a customer, you'll want to push for the highest availability percentage that you possibly can. Typically, customers do like to go for at least 4 nines. Next slide, please. All right, so this should say tips on retaining control of data. Next slide, please. So at the crux of these SaaS transactions is data ownership. And an important question to consider is, what data inputs are you providing to the vendor and what outputs are you getting back? And then who should own that data? Typically, ownership is tied to the definition of customer data, so you'll want to make sure you review that definition very closely. Usually, customers want to reserve ownership rights in all of the data, including their inputs and all outputs. So they'll push for a broader definition of customer data. On the screen, you'll see 2 examples of how inputs and outputs are covered in the definition of customer data. On the left, we have inputs, which includes all data, information, reports, and other content that your organization or authorized users load into the solution. And then on the right are the outputs, which are all the data that is generated by the solution based on your inputs. So typically in a vendor's form, you won't see the outputs included in the definition of customer data because vendors do like to have rights to that data. But given that the output is generated based on your specific data, the output could be information that is sensitive and critical to your organization. So you'll probably want to negotiate outputs into the definition to ensure you not only own the data you provide, but also the data that's generated using what you provided. Next slide, please. All right, return or destruction of data. So the contract should clearly require the vendor to return all of the customer data at the end of the contract term, or at least provide enough time after termination for you to retrieve that data yourself. It should also require the vendor, if you request it, to permanently delete all of your customer data from their systems at the end of the term. And then that return, retrieval, and deletion obligation should be at no additional cost to you. But sometimes the vendor will require an additional fee, especially if you want the data back in a particular format that is outside of what they typically provide. And in that case, the additional fee really should be negotiated up front in the agreement rather than subject to mutual agreement at a later time, to avoid a situation where the vendor holds your data hostage during a cost dispute. So you want to negotiate those up front when you still have some leverage. On the screen, you'll see some example language. The third bullet provides an example for requiring the return of all of your customer data, and the fourth bullet is an example for requiring the destruction of your data. And more often than not, you'll see these two obligations combined into either one sentence or one clause, and that is perfectly fine. Next slide, please. Use limitations. So of course, you should include contractual terms that outline both the permitted and the prohibited uses of your data. And as a customer, you'll typically want to allow the vendor to only a right to only use your data for the limited purpose of providing the solution to your organization and performing the services you've contracted for, and then prohibit any use or monetization of your data outside of your business relationship with that vendor. So the first bullet provides an example of how that use limitation might be contractually stated. Item 1 covers the use limitation I just described, and item 2 covers the restriction against using the data outside of the business relationship with you. So on the other hand, though, vendors typically will want the ability to monetize your data. So we are seeing a trend, particularly for AI vendors, to grab ownership or other rights in aggregated or de-identified data. And the argument is generally that it is baked into the cost and it's used to benefit all of their clients in that it improves their product. And while that might be true, customers tend to be reluctant to give away rights to aggregated de-identified data, particularly with respect to sensitive or personal data, because there is always a question of whether that data can be effectively aggregated and anonymized. You know, think about situations where the customer is either a significant market player or one of the vendor's largest clients, and 80% of that data set comes from that particular customer. Can the customer actually be anonymized, or can the customer be easily identified given the overall data set? So you'll want to think through how sensitive or proprietary the data is to your organization and whether the aggregated data can really be anonymized to avoid a situation where the confidentiality or proprietary nature of your data is compromised, given that the vendor will want to use that data for their own purposes, including to provide services to other organizations. Next slide, please.
Hi, Maha. I'm going to jump in here just to point out that we are at a little after 11, and this is a lot of great content that you guys have shared so far. So just to make sure that people have an opportunity to get all this information, and there's more, I would like to propose that we do a part 2 of this presentation. Josh and I were chatting offline. And so to our viewers, please know that we will be covering more information related to technology agreements in a part 2. We'll let you know what that date is as soon as we have that settled. But this is a lot of great information. Thank you so much, Maha and Josh. I did want to ask one question, if you have a chance, related to something you mentioned earlier, Josh, that, you know, salespeople do a good job. They sell. And so sometimes what they say they're offering doesn't look like what's in the agreement. What's a nonprofit to do when they're trying to balance those two?
Yeah, it's a common issue, right? And honestly, it's it's funny that we'll help clients get to the contract negotiation stage, and we'll try to put in some commitments that that our clients had gotten from the vendor sales teams during the sales process. And the answer is usually, well, from the vendor's lawyers or from the vendor's contracts people, well, they may have said that during the sales process, but we can't put that in the contract. That should be a pretty big red flag if you hear that. I think that the way, again, to guard against that is that, keep as a customer, keep the sales material and try to get everything from the salespeople in writing. And yeah, I think, like Maha said, if it doesn't go into the contract, it's not part of the contract, right? So a good way is to attach whatever those commitments are, or whatever the description or the specifications were that was sort of sold during the sales process. Get that in writing and try to attach it to the contract. And like I said, again, if the vendor lawyers or the vendor contracts people are pushing back on that, it's a red flag. I mean, you probably don't want to use that tool then as a customer. So I hope that answered your question.
Yeah, definitely. And I want to say, Maha and Josh, thank you so much for joining us today, to our nonprofits who tuned in. Thank you for joining us. We'll have a part 2 of this sometime in the next few months. So stay tuned to find out what that date will be. And that's it for this installment of the Program Partnership of Atlanta's monthly webcast series. Thank you.
Great, thank you.
Thank you.